I'm Shreya Sinha, and today I'm joined by Prasanna S, one of the lawyers who fought for the historic right to privacy verdict. Right to privacy has been declared a fundamental right by the Supreme Court under Article 21 and Part 3 of the Constitution. But information and data have been, collected for the Aadhaar scheme. So how would this, how would this have its implication on the scheme?
See, on 24th August 2017, a 9-judge bench of the Supreme Court not only did they hold that the right to privacy was a fundamental right, they also held that the conditions under which such a right can be restricted are very narrow, right? So there needs to be a law, first of all. There has to be so if there is any there is any infringement of the right to privacy, it needs to have a statutory backing. So you think about this, the Aadhaar project did not have statutory backing until 2016. But it had been operating under an executive notification from 2009. That's not law. So all the data that had been collected till about 2016, what will happen to it, what should happen to it, which means now if it was collected without law, it did not have the authority and sanction of the Constitution. Right? When the Supreme Court held that right to privacy is a fundamental right, it was not as if they hold that it is a fundamental right from today. They are holding that it has always been a fundamental right. Right? And therefore it was a fundamental right even in 2009. So therefore they must have had a statutory backing before they could have collected anything. They could have stored any data, personal data, biometrics, etc. They did not have such statutory backing. Therefore all that data, if we are a rule of law country, all that data, I'm afraid, has to be destroyed.
So the center, to justify the scheme, said that right to life of the poor takes precedence over right to privacy of the elite class. So clearly the government, the center, and the Supreme Court is in contradiction. So who will take the final call on the Aadhaar scheme?
See, this poverty versus privacy, it's a very sorry and unfortunate choice that the government has sought to provide. In fact, the judgment completely debunks that choice that the government is making, because government comes and tells us that the poor don't care about privacy. The poor have other priorities, not privacy, etc., etc. From that, what is clear is that the government either does not understand privacy, or the government does not understand poverty, or both. Because there are so many instances where the poor need privacy, right? They may or may not want it, right? Of course they want it at many places, but they need privacy because they are the more vulnerable of losing privacy. When privacy is a fundamental right, in 1948 there is a Universal Declaration of Human Rights that says privacy is a fundamental human right. Right? You first of all put your people, right, rich or poor, you have put them at a place where they are vulnerable to lose their privacy. Many of them are homeless. And now they say though they don't care about it, therefore I will not even guarantee as a right. It's a very unfortunate stand that the government took, and I'm very happy that it's been debunked by the judgment, particularly paragraphs 154 to 157 of Justice Chandrachud's judgment. And also, it needs to be said that, it is an elitist concern, etc., etc. So we think about it. Lots of people said, even equality was a bourgeois concept, right? It so happens that many of our rights get asserted first by the elite. There is always, therefore, a suspicion that maybe it's only an elitist concept. But then that doesn't mean that the right itself is only for the elite. It gets asserted, but therefore privacy also will need to go through that evolution, right? And I'm sure in this case, in fact, one of the petitioners we have, in fact, the petitioner that I appeared for and I gave my appearance for was Bezwada Wilson, right? Who currently heads the Safai Karamchari Andolan and the movement against manual scavenging. He was, right, the Safai Karamchari Andolan has been responsible for for the Supreme Court case that asked for the implementation of the 1993 Act, and also for the political mobilization that finally culminated in the 2013 manual scavenging law, right? And yeah, so he's been working for the poor since decades, right? Why is he here? Why are Aruna Roy and Nikhil Dey here? Right? These are not people who are there for elitists, right? These are people who want to establish these rights for the poor. And now the government to turn around and say it is only an elitist concern is laughable.
Now, today only, as we know that the deadline to link PAN and Aadhaar has been extended. So, with this verdict, is there any possibility, according to you, that you see a possible striking down or invalidation of the Aadhaar scheme?
Okay, so today there was no statement that the Aadhaar PAN deadline was being extended. Okay, there's a lot of misconception because the government has been putting out very confusing messages. See, this August 31st deadline is no deadline. There is no deadline. August 31st is a very confusing message that is being given. Under 139AA of the Income Tax Act, a deadline has to be announced for Aadhaar PAN linking, before which, if such linking is not done, the PAN would get cancelled for people who had Aadhaar as on 1st July or the 1st July 2017, right? So this deadline has not been announced yet. It requires a gazette notification. No such notification has been issued. There is no deadline. So the August 31st deadline, which everybody seems to be talking about, is that, see, if you have Aadhaar, you don't link your Aadhaar and PAN. If you had filed your income tax returns, those returns will not be processed. So what does will not be processed mean? Exactly. It means that you don't get the refunds. See, because an obligation as a citizen, as a taxpayer, that ends when you file the returns. Processing is an internal department process.
So, and what is this December 31st
deadline? There have been a number of notifications issued under Section 7 of the Aadhaar Act, making Aadhaar mandatory, say for instance, midday meal scheme, for the public distribution scheme, scholarship schemes, etc. There have been nearly 111 notifications issued by various ministries, many of them copy-paste of each other's notifications without application of mind, right? So all of those notifications earlier mentioned the June 30 deadline, then was extended to September 30. Now we were told by the Attorney General in court when the counsels for the petitioner mentioned the other matter for early hearing, Attorney General stood up and said that this deadline is going to be extended till 31st of December.
And the case of this mandate, for linking the Aadhaar and the PAN is already being heard in the Supreme Court, right?
So the Aadhaar PAN linkage case, so there are a number of grounds in which it was challenged. So on some of the grounds, the provision 139AA has been upheld. Okay, there is a partial stay with respect to people who did not have Aadhaar as on 1st of July, but otherwise it has been upheld. But there are still some grounds that the judgment refused to consider. And so those are grounds. For example, there is an Article 21 violation. That they said we should re-agitate before this bench, the larger Aadhaar bench. Because it was still pending before the larger bench, it did not want to go into it. Now that the larger bench has decided, now we can re-agitate this matter, and we may get a strike down of 139AA that makes it mandatory for PAN and Aadhaar linking.
So in India, if I'm not wrong, we still don't have a separate law for safety of data, right? So with this verdict, do you see a possibility of such a law being legislated?
So during the hearings, so the Attorney General said, in fact, the Additional Solicitor General who appeared for UIDI also said that there was going to be a committee formed under Justice Sri Krishna. Right? That it also has 9 other members in it. So, I mean, there are problems with the composition of that committee, right? We see that committee does not have as representative voices from people who worked in the data protection related issues here from civil society, etc. Therefore, there are some problems with the composition of the committee, right? It has been headed by a former judge, so Justice Sri Krishna, right? So, very happy about that. Let us see what that committee has to produce. So we hope that the committee also listens to other voices from the civil society, etc. Because data protection, there are a number of issues involved that will require a fair bit of public discourse, discussion, and debate before a law can be passed. I'm not sure. It is important because we now at least have a national conscience that it is a fundamental right. And therefore, that will go a long way towards pushing towards data protection legislation. But you think about it, data protection legislation is for protecting data collected, stored and used by private players of other private persons, right? But what is at stake in the Aadhaar case is actually what the state can do qua its citizens. Because between the state and citizen, the relationship is a very interesting one under the Constitution. It's not the same as, say, the relationship that exists between citizens as private persons, right? And the principles involved in settling settling of the terms of the relationship between the two are different when it is between the state and the citizen versus between two citizens. Therefore, this judgment is more about the former rather than the latter, although there are some observations by different judges on what should go into such a data protection legislation. Yes.
During the verdict, the Supreme Court also made some landmark observations regarding sexual preference, right? So the LGBT community was elated. Yes. So is there a possibility that the 377 can be struck down?
There's a distinct possibility that will happen. That there's a curative petition pending, and if the curative petition is allowed, because there are also procedural questions, procedure of whether, because there has already been a curative petition that is dismissed, whether a second one may be allowed, on what grounds can it be allowed, etc. Those are very procedural Supreme Court questions that are involved. Once, if the curative is allowed, then it is likely that because the ratio of the reasoning behind the Supreme Court's original decision to recriminalize 377, because the Delhi High Court judgment had decriminalized, so Supreme Court virtually recriminalized 2013. So that judgment, so that has been the legal reasoning behind that judgment has been overruled here. So very likely that there is reason to celebrate. I think it's just a matter of time.
One question here. In 2013, the Supreme Court also said that the decision to amend or repeal would be with the Parliament. So now you're saying that it is possible because the reasoning has been debunked that it will be invalidated.
No, now we are not left at the mercy of the Parliament, right? So Parliament is normally many of our rights, we don't leave it at the mercy of the Parliament. Yeah. Parliament by a majority can do A or B or C, right? Many of our fundamental human rights, we don't leave it at the mercy of the Parliament. So it's good that it has come back in the courts of the court, right? So, and hopefully it will be a positive verdict for the LGBTQ community.
The Supreme Court also, apart from 377, spoke about euthanasia, abortion, and right to wear what you want. Can you just elaborate on these a bit? Like, how can it be? What kind of implications would it have? Euthanasia, abortions.
Those are not as concrete observations as anywhere else. So therefore, it would be unwise to say that euthanasia will now be allowed, or to the extent to which it will be allowed, etc. I think it will be too early now to say. Again, on abortion also, so whether the procedure that we now have under the Medical Termination of Pregnancy Act, whether that needs to be reconsidered, etc. It's a little too early because we don't have a majority of judges expressing concrete views on that. But the recognition that privacy is a fundamental right by 9 judges, that's it. It's an inherent, inalienable, universal, basic human right. I think that will go a long way towards settling many of these questions. If, for instance, there is another petition that is seeking to change the way in which we do our medical termination of pregnancy jurisprudence, I think it will have an effect there. This judgment will have an effect in that petition, but it's too early to say.
So, what has been focused after this verdict is Aadhar, 377, then whatever we spoke about, abortion. Is there any other cases that maybe we are not focusing on, but which could have an effect because of the verdict that media is not speaking of right now, but it could have an effect? Like DNA profiling, there are so many things.
DNA profiling bill, I think it is being considered by the Parliament. So that is going to have a serious impact on privacy. I mean, it's like now we are talking about collecting biometrics. They want to collect DNA of every Indian citizen. Right? So obviously that's going to have an impact there. And the other one is the one that you may want to watch out for is the WhatsApp user sharing case. So the WhatsApp and Facebook. So there's a user sharing agreement. So that agreement was challenged in the Delhi High Court. Now it's come to the Supreme Court. There's going to be a hearing on this Friday, if I'm not wrong. Friday, I think, the 1st of September. So let's see where it goes. So there are a few cases to watch out for on privacy that are coming up in the next. And Aadhaar itself is, as you know, so the matter was mentioned today and it will come up for final hearing in first week of November.
Does this verdict, this is my last question, does this verdict entail any reasonable restriction? And if so, what are they?
See, reasonable restrictions on a right. So that restrictions being reasonable has been there in our jurisprudence ever since the Constitution was born, right? So the conditions under which the fundamental right to privacy may be restricted, right? So there is a difference in semantic as to how those conditions are laid down by different judges. But broadly speaking, there is an agreement that there needs to be a law, first of all. That law has to be fair, just, reasonable. The law itself has to be fair, just and reasonable. And the restriction that is sought to be imposed on the right must be proportionate to the objective sought to be achieved. And the objective sought to be achieved must also be a legitimate objective. So these are four-pronged tests that the Supreme Court has broadly agreed on.
Nothing in particular as of now.
This is the four prongs. In fact, this is a very particular test that they've actually laid down for state action.
So thank you so much, Prasanna, for joining us. It was really helpful getting his insights. That is all for today. Thank you so much.